who was a member of the Canadian Parliament, Emeritus Professor of Law at McGill University, and former Minister of Justice and Attorney General of Canada. He served on the Standing Committee on Foreign Affairs and its Subcommittee on Human Rights and International Development, as well as the Standing Committee on Justice and Human Rights. Professor Cotler is a staunch advocate for Israel. He is a constitutional and comparative law scholar who has actively litigated landmark cases in the area of war crimes and minority rights, and has received numerous awards for his pioneering work in peace law and human rights advocacy, including Order of Canada. As part of his role as Justice Minister, Professor Cotler was tasked with reviewing and eventually with passing Canada's Anti-Terrorism Act. Please welcome Irwin Cotler.
Thank you, Rach, for those very kind words of introduction. I heard about yesterday's excellent day from an expert witness, and that was my wife, who was here for the day and told me how exemplary the proceedings were. I'm going to share some thoughts and perspectives and some proposals with you today about the whole issue of lawfare. And, you know, in fact, in speaking about lawfare, I'm reminded of Clausewitz's aphorism that war is the continuation of politics by other means. I want to turn this around and say that lawfare is the continuation of war by other means. And I'm referring in particular to the war of delegitimization, or if I can be more express and specific, what I would call the laundering or masking of delegitimization under universal public values. And my main thesis is that this is not simply a threat or prejudicial to Israel, though it is that. It is a threat and prejudicial to these universal public values. And here I'm referring to the protective cover of the United Nations, the authority of international law, the culture of human rights, the struggle against racism. And so when you mention, Rachel, that I come as an advocate of Israel, I come here today, and that has been the manner in which my advocacy for Israel has been anchored, with respect to the pursuit of international justice. I come to the support of Israel not simply because it's a Jewish cause. That would not be enough for me. I come to the support of Israel because I believe on the facts and on the law, with whatever imperfections there may be in its case. It is, at the end of the day, a just cause. And if it is a just cause, then it deserves the support of all men and women of goodwill in each of our countries in the national community. So let me deal today with 4 manifestations of the laundering of delegitimization under universal public values. For reasons of time, I will deal with only one example under each of these manifestations, though one could write a book about each one of them. The first is, as I mentioned, the laundering of delegitimization under the protective cover of the United Nations. Every year at the General Assembly, in what has become an annual ritual that has been proceeding now itself for over 40 years, every year the United Nations General Assembly adopts some 20 resolutions of condemnation against one member state of the international community, which happens to be Israel, and only 4 resolutions against the rest of the world combined. Now, I'm not telling you anything that you don't know, but in legal terms and in terms of international justice, what we are witnessing here is a standing denial of international due process, where one country is singled out for differential and discriminatory treatment, and the rest of the human rights violators enjoy exculpatory immunity. And when one looks at the resolutions that are adopted, they read, and not accidentally, they read like legal judgments, alleged findings of fact and conclusions of law. And they focus increasingly on the settlements, because those who drew up and draw up these indictments know very well that America, Canada, Europe are legal cultures. If you say something is illegal, it's far worse than if you say it's stupid or ill-advised or wrong. And so you have a series of resolutions dressed up as legal judgments, increasingly focusing on the illegality of the settlements, with all the resonance that that would have in legal cultures in North America and Europe. But it doesn't end there. As someone who is a member of a Canadian delegation to the United Nations, in the course of the adoption of these resolutions, you have to appreciate that there's not only a critical mass of indictment in the singling out of one member state, but a critical mass of exposure to that indictment. Because these resolutions pass through a 3-month process. Almost every single day, somewhere, there is a meeting, a forum, a conference on the way to the indictment. And the delegations to the United Nations are made up not only of diplomats, they include parliamentarians, academicians, journalists, NGO reps, faith leaders, and the like. So there's a critical mass of exposure to the process that leads to the final indictment. And most of the members of these delegations, as I witnessed when I was there, don't necessarily come to the United Nations with any particular bias against Israel. It's that they come there uninformed about Israel, but they listen to and are exposed to this drumbeat of incitement for 3 months. And at the end of that, they internalize that drumbeat of incitement and then end up seeing Israel through the same optic of those resolutions which effectively brand Israel as a major lawbreaker in the international community. So that's the first manifestation of the laundering. The second is the laundering of delegitimization under the authority of international law. Now, you've heard about this, and I could speak to this, whether I would reference the International Court of Justice judgment, or the ICC, or Universal Jurisdiction. I want to take one particular example because it is so compelling in its outrageous selective discrimination and prejudicial impact. I'm referring to where the contracting parties to the Geneva Convention convene with respect to the Fourth Geneva Convention on the Law of Armed Conflict, exactly what you are speaking about in terms of the laws of war. And on December 17th, 2014, the state parties to the Fourth Geneva Convention convened to put one state in the world in the docket. It was not Russia, it was not Syria, it was not Sudan, I can go on. The only state that was put in the docket for violations of the law of armed conflict was Israel. Now, this has happened 3 times in the last 50 years. Each time, the only state put in the docket was Israel. And so what you have here is a laundering of delegitimization under international law in general, under international humanitarian law in particular, but you can begin to see that the damage that is being done, the prejudice, is being done to the authority of international law itself. Which brings me to the third manifestation, and that is the laundering of delegitimization under the culture of human rights. And here I will take one case study, as I said I would under each manifestation, and here I'm referring to the United Nations Council on Human Rights, which is now commemorating its 10th anniversary as the repository for standard setting in international human rights and the successor to the UN Commission on Human Rights. Now, it's not only that. Some 50% of its resolutions single out one member state in the international community. Again, you know what that state is. It's not only that some 50% of its special sessions and emergency procedures, again, single out one state. It's not only that at every meeting of the UN Human Rights Council, every meeting, and I've been there and I've witnessed it, it begins with one agenda-specific item relating to Israel and an agenda item for the rest of the international community combined. So what you have at every meeting of the UN Human Rights Council is that one member state is singled out for indictment even before the hearing begins. And that's why, in a situation such as commissions of inquiry, whether it be the Goldstone Commission or whether it be Operation Protective Edge, if you look at the resolution establishing the Commission of Inquiry and taking Operation Protective Edge as a case study, there are 18 separate references to the alleged criminality of Israel. I say alleged, but the resolution reads as if it is a statement of fact and law. 18 separate references to Israeli criminality in the establishment of a commission of inquiry to look into the question of whether there has been any violations of the laws of war, and not one reference in that resolution establishing the commission of inquiry to Hamas. You know, an Alice in Wonderland situation in which the judgment is pronounced even before the hearing begins. And I face this as well. In 2006, I was invited by the then UN Commissioner on Human Rights, Louise Arbour, who had been a colleague. We had taught together at Osgoode Hall Law School. She was a member of the Canadian Supreme Court and then had become the UN Commissioner on Human Rights. And she called me up and she said, Irwin, the United Nations Council on Human Rights will be establishing a commission of inquiry to looking into the killings of Palestinians in Bet Hanun in northern Gaza. Bishop Tutu will be one member of that commission, and we'd like you to be the second member. And I said, will this commission of inquiry be visiting Sderot? And she said, no, why would it go to Sderot? And I said, well, it's because rockets were being fired from Bet Hanun to Sderot on a systematic basis, that when Israelis responded to that rocket fire, regrettably, one artillery fire went astray and Palestinians were killed. She said, no, it won't be going to Sderot, but you'll be a member of that commission. You'll be able to speak to the issues. I said, Louise, I've read the resolution establishing the commission of inquiry that you're asking me to join. It says in its resolution establishing the commission that Israel willingly murdered 18 Palestinians in Bet Hanun. So what is there to investigate? You've already predetermined the outcome. I said, I'm sorry, I don't intend to be a fig leaf for the UN. I certainly don't intend to be a Jewish fig leaf for the UN. Which brings me to my fourth manifestation, and this is the laundering of delegitimization and lawfare under the struggle against racism. Let's face it, one of the worst things you can say about anyone in the world today is to call them a racist. The very label supplies the indictment. And in the case of Israel, you don't only refer to Israel as a racist state, as was done in the Zionism as racism resolution, but now you refer to it as an apartheid state. But apartheid is defined in international law as a crime against humanity. Therefore, this calling of Israel an apartheid state is not happenstance, because people know that if you refer to Israel as a crime against humanity, then if it is a crime against humanity, this state has really no right to be. And if that is not enough, then you call it a Nazi state. So not only does it have no right to be, but there is an obligation on the international community to ensure that it has no right to be. And in polls that were done with respect to taking some 8 European states as case study, some 40% of its citizens, when asked, do you believe that Israel is behaving towards the Palestinians the way the Nazis behaved towards the Jews? 40% answered yes. And so we see the cumulative impact of the laundering of delegitimization under the rubric of the struggle against racism. And so the question then becomes, what do we do about all this? And what do we do about this lawfare? For reasons of time, I'm going to make some suggestions or proposals. This is an informed audience. You don't need any elaboration from me. But my generic principle and proposal here is that we have to come out of the docket of the accused, where we are always framed as the criminal defendant, and become the plaintiff, become the claimant. Not only the plaintiff or claimant on behalf of Israel, but the plaintiff or claimant on behalf of these universal public values. In other words, become, if you will, a melitz yosher, a public advocate for the very universal public values that are themselves being denied or corrupted in this laundering of delegitimization. Because if we make the case, and this is my first point, if we make the case simply that delegitimization is prejudicial to Israel, then the answer will be, well, it should be prejudicial to Israel. Israel deserves to be delegitimized. It is a major human rights violator, etc., etc. And so the point has to be made here that this laundering of delegitimization is prejudicial to these universal public values. And purportedly, certainly I can speak in terms of my own country, Canada, where the United Nations is part of our DNA, where international law is spoken of as a centerpiece of our identity, where human rights is held out to be an organizing idiom of our foreign policy, where the struggle against racism and hate was one of my first priorities as a Minister of Justice. If, as in Canada and in other countries, people mobilize around, embrace these universal public values, then our principle and position should be, it is that the laundering of delegitimization is eroding the integrity of the United Nations. It is diminishing the authority of international law. It is corrupting the culture of human rights. And it's demeaning the real struggle against the real racism. As someone who was involved in the struggle against apartheid, who was even arrested in the course of that struggle against apartheid, to say that Israel is an apartheid state demeans the real struggle against the real apartheid. Because if you say that Israel is like South African apartheid, that means that South African apartheid had a universal franchise, had an independent judiciary, had NGOs running around all over the place, rightly and good, in order to critique its government, was anchored in the rule of law and the like. That's why I say it demeans the real struggle against the real apartheid. And in this instance, it not only delegitimizes Israel, but as I said, in a world in which human rights has emerged as the new secular religion of our time, to say that Israel is an apartheid state, to say that Israel is the meta human rights violator of our time, is effectively to say that Israel is the new geopolitical antichrist of our time. And that's why I say we've got to combat the delegitimization, this laundering of delegitimization, by saying how prejudicial it is to these public values. The second thing is to call upon the United Nations to adhere to its own United Nations charter, to respect international due process, to adhere to the principle of equality before the law for all nations, large and small, as set forth in the UN Charter, to cease and desist of giving exculpatory immunity to the major human rights violators, to put an end to the culture of impunity enjoyed by these human rights violators, and to begin a process of reforming the UN Council of Human Rights, and specifically with putting an end to every meeting of the UN Human Rights Council, beginning with an agenda-specific indictment against one member state of the international community. So instead of just lamenting what the UN Council on Human Rights or the UN is doing, we should begin and embark upon a reform proposal with respect to the UN in terms of getting it to adhere to its own principles and its own undertakings, and specifically in the matter of the UN Council on Human Rights. Number three, we need to reverse the conventional paradigm of the Mideast process. For too long now, the conventional paradigm has been that the Israeli-Palestinian conflict is the source of all conflict in the Middle East and beyond. The occupation is the source of the Israeli-Palestinian conflict, and apartheid Israel is the source of the occupation. Well, we have to turn that paradigm around on its head and make it clear that it's Arab tyrannies and radical Islam that is the source of all conflict in the Middle East and beyond. That the unwillingness to accept the legitimacy of a Jewish state in any borders is the real apartheid in our time. And that the public call for the destruction of Israel and the killing of Jews wherever they may be, whether anchored in the Hamas covenant or anchored in the dictates of radical Islam or anchored in the declarations of the leader of Iran and the like, that these amount to a criminal, racist apartheid, and we have to undertake the legal remedies in the international community to combat it. This brings me to a fourth, and I'll move more quickly. With regard to Iran, now that there is a nuclear agreement, we have to realize that the process of negotiating that nuclear agreement, let alone the nuclear agreement itself, has served to overshadow and, in fact, sanitize the other four Iranian threats, which continue and continue as threats to international peace and security. I'm referring to the terrorist threat, where Iran is the leading global state sponsor of terrorism. I'm referring to the hegemonic threat in terms of Iran's aggressive hegemonic conduct in the Middle East and beyond. I'm referring to the incitement threat, where you have state-sanctioned incitement to hate and genocide as a standing violation of the Genocide Convention. And I'm referring in particular to the massive domestic repression in Iran, whether it be the singling out and targeting of the Baha'i or the gender apartheid and the like. I have to tell you that when I would go to university campuses, when I would speak about the Iranian nuclear threat, very often students would roll their eyes. But if you spoke to them about the massive domestic repression, if you spoke to them of the singling out and targeting of religious and ethnic and cultural minorities with respect to the discrimination against women, with respect to the execution of children, with respect to the fact that Iran executes more people per capita than any other country in the world today, and that this has doubled the rate of execution, more than doubled under the moderate Rouhani, then they begin to get the point. That the danger is of giving a country that so massively represses its own citizens that allow that country to become a nuclear threshold state. So we have to reframe the way we are making the cases in that regard. Number 5, we need to speak more in terms of the international community's protective responsibility for the targeted minorities in the Middle East, be they the Yazidis, be they the Kurds, be they the Ahmadiyyan Muslims. I don't need to belabor this point. You understand it clearly. Number 6, with the matter in a matter of anti-Semitism. Recently, a very important development took place. That is, the 31 member states of the International Holocaust Remembrance Alliance adopted a comprehensive and inclusive definition of anti-Semitism, which relates to the new anti-Semitism, the singling out of Israel for differential and discriminatory treatment, and not just the classical anti-Semitism. And if you need another template in this regard, I should tell you that a little over a year ago, the House of Commons, the Canadian Parliament, unanimously, and it doesn't happen often, unanimously adopted a resolution which had 3 parts to it. Number 1, it condemned the alarming international growth in anti-Semitism. Number 2, it called on the Canadian government and Parliament to make the combating of anti-Semitism a priority both in its domestic policy and in its foreign policy. And number 3, and the most important part, and this relates also to what Ira just did, and I'm just excerpting from the Ottawa Parliamentary Protocol to combat anti-Semitism, which was adopted in this unanimous resolution, which says as follows: criticizing Israel is not anti-Semitism, and saying so is wrong. But singling Israel out for differential and discriminatory indictment, denying Israel's right to exist, let alone calling for Israel's destruction, is hateful and discriminatory and anti-Semitic, and not saying so is dishonest. And here is a very good template to use. 2 other proposals, and with this I end. When we hear very often the approach or mantra of 2 states for 2 peoples, very often it lets off at 2 states and doesn't speak to the issue of 2 peoples. And when it speaks about 2 states and for two peoples, let me make full disclosure here. I was a supporter of 2 states for 2 peoples in 1968, long before it became fashionable to do so. But my whole point then and now is that the Palestinians are not only entitled to an independent state, but to an independent, democratic, rule of law, rights-protecting state. Anything less than that is really undermining the principle of self-determination for the Palestinian people. And so we shouldn't speak simply in terms of 2 states for 2 peoples. A core threshold requirement must be, and not speak simply in security terms of a demilitarized Palestinian state, a core requirement has to be that this must be a democratic, rights-protecting, rule of law state. Otherwise, we are undermining the very principle for which we are creating such a state, namely self-determination for the Palestinian people. And I say to my colleagues here in the human rights movement, yes, monitor Israeli human rights violations in the territories and the like. But if you care about the issue of human rights, then where is the monitoring of Palestinian repression of the rights of their own people? That's what equality before the law is all about, and that's what self-determination is all about. And let me close with just one issue here, and that's the whole question of Jewish refugees from Arab countries. I wasn't going to speak to this other than just yesterday I noted that there was going to be another conference with regard to the Holocaust and the Palestinian Nakba. And it reminded me of something that occurred some years ago when I addressed a group of lawyers in Canada. It was a group of Francophone lawyers, and my talk was on the 5 major lessons of the Genocide Convention. And I finished my talk, and a woman in the audience got up and said, Professor Cotler, as you know, I'm a lawyer, and I was a lawyer in the Department of Justice when you were the minister. There was something that I always wanted to ask you, and your talk today gives us the opportunity to ask this question. You spoke about the 5 great lessons of the Genocide Convention. Some of those lessons were things like the danger of state-sanctioned incitement to hate and genocide. She said, but you didn't mention a word about Palestinian suffering. You didn't mention a word about the Nakba, the catastrophe to the Palestinian people. Can you tell us why you didn't speak at all about Palestinian suffering? Why you didn't address at all in the 5 great lessons of the Genocide Convention, the Nakba, the Holocaust to the Palestinian people? I said, you're right, the Palestinians have suffered and continue to suffer. You're right that the Palestinians suffered and endured a Nakba, a catastrophe. At the time I was telling her this, it was on the 60th anniversary that I was speaking of the Genocide Convention, let's say now 67 years ago. I said, so what happened 60 years ago? Now let's say it would be 60s. I said, at the time, the United Nations adopted a partition resolution recommending the partition of then mandatory Palestine into 2 states, a Jewish state and an Arab state. I said the Jewish leadership at the time accepted the resolution. The Arab and Palestinian leadership did not. I said, mind you, they had a right to reject the resolution if they felt that it did not comport with their hopes and aspirations. But what they didn't have a right to do was to then launch a war of aggression against that nascent Jewish state, which they spoke of, not me, as a war of extermination against the nascent Jewish state at the time. What they didn't have a right to do was to then launch a war of aggression against their own Jewish nationals living in Arab countries, dispossessing them of their rights, dislocating them from their homes, arresting them, detaining them, torturing them, expelling them, so that at the end of the day at the time, you had some 850,000 Jewish refugees resulting from this act of aggression of Arab states. I said, in a word, what you had at the time was a double act of aggression, double rejectionism against the Jewish state and against their own Jewish nationals by the Arab and Palestinian leadership. And as I said, it's a tragedy to think that had they accepted the UN partition resolution at the time, we today would be commemorating, if you will, the 67th anniversary of 2 states for 2 peoples, and avoided all the pain and suffering that had occurred since that day. And then she said to me, and this is why I'm telling you the story, then she said to me, do you mind if I say something? I said, please, go ahead. She said, I have to tell you, I consider myself a reasonably well-informed person. I'm a lawyer, I follow public events. This is the first I've ever heard about Jewish refugees from Arab countries. She said, of course, I know some of you are saying, wow, but I'm talking to you, go out there and speak to the non-Jews. And by the way, if I have to make a challenge, if there's some 500 people here today, then I would say that each one of you, I won't say next week or even next month, in the next few months should undertake to sensitize, make 10 non-Jews better aware of the Jewish people's case and cause, which is really what I say, the universal case and cause. So as a result of this meeting today, you can have some 5,000 non-Jews in 3 months better aware of the case and cause. But if you say, well, I'm not sure I know 10 non-Jews to make the case to, that's part of the problem. We're speaking too often to ourselves, and you say, well, I know 10 non-Jews, I'm not sure I can effectively make the case. It's another issue. Talmud Torah Keneged Kulam, the study of learning above all. And that's why this conference is so important. And as I said to this woman at the end of the day, and as she said to me at the time, that not only did she not know about Jewish refugees from Arab countries, but continued to say, yes, of course, I always knew about Palestinian refugees, but I always thought that that was the result of Jewish ethnic cleansing of Palestinian Arabs. We have a lot of work to do. Shurat HaDin is showing us the way, is showing us how to take up case and cause, and at the end of the day, as I always feel about these things, at the end of the day, Netzach Yisrael lo yishaker, that at the end of the day, truth and justice will prevail. Todah.
Professor Cotler, thank you so much. Thank you so much for making time to be with us. We so greatly appreciate it, and I know you had to pull yourself away from some adorable grandchildren who I know personally. So we really, really appreciate that. Okay, ladies and gentlemen, we're going to take a break now. We ask that you be back in your seats by 10:25. We're going to start at 10:30 sharp.